Really?
All right, good afternoon. We're back in Senate Judiciary, May 28th. We have Ledge Council with us to discuss S45. They just voted it out with the other body and sent it over. Going to get a walkthrough. We also have the chair of the Agriculture Committee here with us. So please take it away.
Good afternoon, this is Mike Green, Legislative Council. You should have in front of you a side by side of S45 this past Senate and the S45 House Proposal Amendment. I will focus on the changes, but I'll just generally discuss what each component of each bill is. You'll see in section 1, there's the amendment to 12 VSA chapter 195, which is the existing right to farm law, the nuisance suits against ag activities chapter. The legislative findings and purpose in both versions has not changed. It is still the purpose of the chapter to protect reasonable activities conducted on the farm from nuisance suits. Then you get to the definitions section. It is the same. So you have the same definition of agricultural activity, farming, ag activities as defined in Title 6, except that on page 3, in the definition of generally accepted agricultural practices, that standard which will be used to determine whether or not farming is entitled to nuisance protection. The House added, in addition to the RAPs, the requirements of an active concentrated feed animal feeding operation. You will likely remember that EPA has issued a corrective action order against the state requiring A&R to be more engaged and active in permitting discharges from farms. So if a farm needs a CAPO permit, it's not really going to be complying with an RAP provision because it'll be complying with the CAPO permit. And that's why it says where applicable on sub 2A and then also in sub 2B, because a farm that needs a CAPO permit is not complying with the RAPs. They're now subject to a CAPO permit. And then on page 3, a new definition was added in the House. This is a definition that's used in a couple of different ag programs so that persons who are engaged in enforcement actions by the Agency of Agriculture don't benefit from agricultural programs. So as it's defined, good standing means a person conducting an ag activity that is the basis of a nuisance claim does not have an active, unresolved enforcement violation stemming from the agricultural activity and issue that has reached a final order with A&R or the Agency of Ag. The concept here is don't reward a farmer who's engaged in bad behavior with nuisance protection for that bad behavior. So they have to be in good standing, and it's a very small subset of people who ever reach a final order with either agency, because both agencies will work with the respondent, the farmer, to come up with a corrective action plan. And if the farmer's working through that corrective action plan, that it should never reach a final order. It won't. I've only known of 2 in like about the last 15 years.
But if they get a corrective action order, is the claim considered resolved after that?
No, they just don't get the nuisance protection. So the plaintiff is still going to have to show nuisance. The farmer just won't be able to assert that they have nuisance protection. And you will see, moving on to the next section, the 5753, that protection from nuisance. The statement, well, actually, let's first talk about the Senate passed version had protection from nuisance and trespass. The House has completely removed any reference to trespass. There's no protection for trespass in the House passed version. But the statement about no agricultural activity shall become a nuisance when the activity is conducted in accordance with generally accepted agricultural practice, that is the same in both versions. But then you will see, in order to assert nuisance protection, the person conducting an ag activity shall demonstrate that the person at the state, again, they don't have that final administrative order, enforcement order against them. They demonstrate that by providing letters of good standing to a court, the Secretary of Ag or the Secretary of Natural Resources, or both, depending on the relevancy of the claim. And then you move on to
Chair, I apologize.
Yeah.
Can I ask a question? Russ Ingles, Chair of Senate Agriculture. Council, could you just briefly, or whatever you would have to do, with just explain trespass? The definition of trespass.
So trespass is when a person or something they own or control enters the property of another without permission of the property owner and causes damage.
Thank you.
On page 5, one of the things that the Senate wanted to do and that the House has done, but it has enhanced a little bit, is to clarify that the plaintiff alleging that an ag activity is a nuisance shall have the burden of proving by preponderance of the evidence that the ag activity is not conducted in accordance with the generally accepted agricultural practices. Now the House, the first part of the House language on this, it's really just fleshing out that it says the ag activity at issue is not entitled to the nuisance protection provided for under subsection A because the ag activity is not conducted here.
No, no worries. I'm just trying to remember because my brain feels like at this point in the year is complete mush. Preponderance more likely than not, sort of the lowest evidentiary standard.
Yes.
Okay, thank you.
So that first subdivision 2A in the House proposal, it's really the same as what you have. It's just kind of maybe a more fleshed out statement of the protection. Or the burden of proof. But what the House did is it wanted to be clear that if the plaintiff somehow overcomes the nuisance protection, the plaintiff still has to show the elements of their nuisance claim. Just because you defeat the nuisance protection doesn't mean that you're successful in your nuisance claim, and they wanted to be clear about that. Now, when the bill passed the Senate, there was a statement that the nuisance protection would not apply to activity that results from negligent operation of agricultural activities. That same standard is in the House passed version, but they also have provided that the nuisance protection does not apply when there's a substantial adverse effect on health, safety, or welfare, or the ag activity has an obnoxious and significant interference with the use and enjoyment of the neighboring property. Now, that language might seem familiar to you because it is in the current law. You can see on page 4 that it's in struck out language, but under the House proposal sub 2 right there in the middle of the page, the presumption that the agricultural activity does not constitute a nuisance may be rebutted by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the enjoyment of the neighborhood.
So, Mike, oh, sorry. I was going to say the noxious and significant interference. I can't remember it off the top of my head, but is that not? Are those not the elements of nuisance?
No, it's not. So nuisance is a substantial interference with your use and enjoyment of the property. Of your property. And so this I was just reading a case. Noxious is beyond just substantial interference. It's a standard that invokes harm to your health or your well-being, and it's an evidence-based standard. So the courts will take testimony from experts and witnesses to determine if that standard, that behavior rises to a level of noxious interference.
So why is it significant interference rather than substantial interference? What's the,
You know, I think it's because when the House was debating this, they took testimony from a particular advocate, and the particular advocate pointed to a certain state that has that standard. That's what they asked to be included in the bill.
yeah, I mean, I'm just trying to fully wrap my head around that piece because it's substantial interference with the use and enjoyment of your property. That's nuisance, right?
Mhm.
And this is saying significant interference with the use of enjoyment of property and a noxious effect as well. So is it, I mean, the way I'm looking at it, it almost seems like it's nuisance plus the noxious element.
But remember, you have to, in order to bring your nuisance claim, you have to defeat the nuisance protection.
Yeah.
One of the ways you defeat it is by saying that the activity has a noxious and significant interference with your use and enjoyment. You know, it's similar to the existing standard, but it is a step up. It's not just that interference with your use and enjoyment of your property.
So when you say it's, can you describe what you mean by when you say it's a step up?
It is a higher standard that you will have to show that the activity poses.
And that is on the burden of the plaintiff. Yeah.
There's some language that happens in the current law that was struck in the Senate passed version that the House wanted to reinsert, that the chapter shall not restrict or impede the authority of the state to protect the public health, safety, environment, or welfare. So the state does have whatever enforcement or public health or environmental authority it has. This does not dictate that. And then moving on from.
So I got a quick question here, Mike. Using the term noxious. Now I just looked it up, obviously, harmful, poisonous, or very unpleasant. This then in the nose of the beholder as far as liquid manure being spread out next door. I mean,
I literally was just reading the Area Holdings case, the Portobello case. And although the judge did not decide that case on nuisance, she decided it largely on trespass. She did discuss to a large extent what noxious meant. And she discussed that it's a fact specific determination about taking testimony from experts, taking testimony from witnesses, determining how it has affected, how the activity has affected their use and enjoyment of their property, their health, their lives. So it is a standard that will depend on the court and each situation.
Senator.
But that is in current law, right? Isn't what we're changing here actually making the threshold for what is considered a nuisance higher than what it currently is?
So what it's doing is it's the bill really does three main things, and Rep. Durfee, who reported it on the House Court, does a good job of summarizing that. First, it shifts the burden to the plaintiff away from the farmer to show that the farmer is not entitled to nuisance protection because of negligence, adverse effect on health, safety, or welfare, or actions and significant interference. Second, it is clear that a farm can change its use or change its type of farming or even begin farming and still qualify for the protection, because under the existing law, the activity had to have existed prior to neighboring uses. And that's really hard to do, especially when farms are being encouraged to diversify, encouraged to start up. If they're not going to get that nuisance protection when they're changing use or diversifying, it's difficult. So this bill would give them protection for new or change in use. And third, it basically it effectively changes the standard for what that has to be shown by saying to overcome the nuisance protection by its negligent, substantial adverse health effect or noxious and significant interference. So it is not a significant change from the existing law, but there are 3 changes which are intended to be helpful to farmers.
And that would be what? That's not the way I read the bill, but that would be what?
So the plaintiff has the burden of proof.
That's right. Rebuttable presumption is gone. It should have been there to begin with. My right?
Rebuttable presumption is gone.
They removed the trespass.
Well, they did. That was not in current law. That would have been a proposal from your body. And yes, they removed trespass, so there would not be trespass protection. They allowed for protection for change of use of type and new, which is not in the current, but it was in yours. And it changed effectively this standard for how you qualify, that you are just need to be conducted according to generally accepted agricultural practices,
Which hasn't been defined as of yet.
well, the 4th component hasn't been defined, and there was debate about removing that 4th component and just having the nuisance protection apply if you were complying with your RAPs, complying with your CAPO permit, or complying with the pesticide rules. And that would have made it easier for farmers to assert the nuisance protection, but it would have actually not provided them protection for things like noise or dust or odor, which are not covered by the RAPs or the CAFO permit or the pesticide permit. So it was if you took away that narrative in conformance with customs and practices, you would be theoretically providing them, the farmer, with more protection, but also theoretically opening up like this whole universe of cases to argue significant interference with use and enjoyment or adverse health and effect, because there would be no standard there to look at as to odor and dust and vectors and tests. So it's going to be factored back to your, it will need to be determined, and it may change on a case by case basis depending on what the type of activity is, because what's normal and accepted in the area for drainage in one area, Addison County, is not the same as it would be in Bennington County, because the differences in the soils and what you have to do in each of those counties to manage the flow of water in each of them. Bennington's sandy, Addison's clay. You have to do different things in those different counties to manage your flow.
Well, and looking at the 4 areas of concern that I'm looking at, it was rebuttable presumption, should have been removed it. That's a good thing. They took out the trespass. And I look at the nuisance complaints and look at sections or lines 2 and 3. And I just think that's what watered down for my constituents in Franklin County. I don't think that offers them the protection that we think they're going to get here.
I think that's a viable argument.
All right, the meeting out, go ahead.
So the last section of the bill is that liberal construction, which is partly already in law, but one of the things that the Senate passed version did and the House passed version does. When there is a direction for liberal construction, it's effectively a directive to the court to say, when you're looking at this language, when you're applying this language, don't strictly apply it. Don't go solely by the the definition or meaning of a term or word. You are supposed to apply this in consistent with the policy and the purpose of this chapter. And that's what liberal construction is. It's really a directive to the court. Now, in the Senate passed version, there was language on page 6, which said an ag activity shall not lose its nuisance or trespass protection due to a change of ownership or cessation of operation. You already have that protection and the definition of what an agricultural activity is. A change of crops, you already have that protection and the definition of ag activity. Change of farming method, you already have that in the definition of ag activity. So it was determined that sub B on page 6 was just not necessary because it's already covered. And then last, the required mediation prior to suit is unchanged except for the removal of trespass from the Senate passed version.
Any questions?
I feel good about it. House change it. I wouldn't vote for it.
I just think that, what, Senator Norris raises is what would keep me from supporting that bill. It just needs to be a little bit stronger right there. And just not open up the door quite so much. I certainly don't want, bad farmers to be protected in any way, shape or form. But I don't think that the door needs to be open any wider than what it is right now. To have them, go through the process of, I don't think that anytime you're charged with anything, even though this bill would keep farmers from having to prove themselves innocent. I mean, that claim isn't on, or that duty isn't on them right now. But to open the door at all, is a dangerous thing, and it's not a fun process. Go ahead.
Well, I'm not sure I understand. My understanding of this bill is that this is more protection than farmers currently have.
Well, the 4 things when you get down through, and I'll let Senator Norris go down through and have this argument with him because that's what made sense to me. But I think, Senator, that there is some more protections on them, but it's loosened up protections in other areas to start the process of a complaint.
Thanks.
Are you referring to the sections 2 and 3 regarding the substantial adverse effect on health, safety, and welfare, and the noxious and significant?
Yes, Mr. Chair.
Yeah, I mean, I'll be curious to see what Steve Collier has to say tomorrow morning about this. I mean, at first glance, actually a question for Ledge Counsel. Can you remind me, the plaintiff has to meet what burden when it comes to proving that there's a substantial adverse effect on health? So
They're gonna have to show that. It's gonna be an evidence-based standard. They were gonna have to show expert testimony, witness testimony that there's been a substantial adverse effect on health.
so clear and convincing.
Honors of the evidence.
Honors still on all this. That's a shell.
Well, they need to show that it's more likely than not that the activity had a substantial adverse effect on their health. And all that does will remove the nuisance protection.
Right.
And then they must still prove the elements of the actual nuisance in order to prevail. Right. Okay. Any other questions? Comments?
Well, I can tell you, since I'm Senator Volsky, I express her opinion. I don't like it and I can't support it. Messenger. That's all. Just had to get that on record.
Good stuff. Well, thank you for coming on short notice. We will see you tomorrow morning and then take it from there.